honorable members of the National Assembly who followed his intervention. I have also listened with a lot of interest to the trip down memory lane that Honorable Ivan Kolendablu embarked upon. And I must say that he has said a few things that I would tend to agree with. For instance, when he made reference, and he said that in French, if I quote him, comment peut-on demander au judiciaire, the Judicial and Legal Service Commission, de nommer un membre de l'exécutif? You see, that is an admission on the part of a seasoned member of the bar, as well as a seasoned member of the National Assembly, whom I have a lot of respect for. Basically what he's saying, and that is indeed, for me, a very important thing that I ask friends on all sides of the House to take note, that he is saying that the nomination of the Director General is in fact the nomination of a member of the executive. So that is où le bas blesse. And if he says that the Judicial Legal Service Commission cannot proceed avec la nomination, he therefore agrees that therein there is a problem. And there is therefore the need, because when I've listened to everyone, there is the need for us to find another method by which such a nomination can take place. But then again, the Honorable Prime Minister has, in a very intelligent manner, refrained and not responded to the following question that exists in the members of the public. And the question is as follows. Why remove the Director of Public Prosecutions from the whole equation? That is the question. Because the least that I would have expected, and the least that a civil society would expect, is for the Honorable Prime Minister to come here today and tell us, has he had consultations with the Director of Public Prosecutions? Has the government not thought it fit that there should have been consultations, if it was not for him, for any other reason? He may have not to want to meet the DPP, but shouldn't the DPP have been consulted at least by the Attorney General? Shouldn't the DPP have been consulted at least by le Secrétaire du Cabinet or the Solicitor General? And if such consultations did take place, what was his reaction? This is what we need to know. Because we have all been talking about the powers of the DPP, according to some members of the House, eating away some of the powers of the DPP. But we are therefore entitled to expect that a government that respects the provisions of the Constitution and understands the parameters and meaning of the word consultation would at least tell us whether they have met with the DPP and shared views, and if so, what were his views? And if they haven't met with the DPP, why not? We expect to know. You see, Mr. Speaker, sir, let me quote a very important person in this legislature. He said a few things, and I listened very carefully and wrote down verbatim what he said. I quote, "In fact, Mr. Speaker, sir, when I looked at the case file, because, he said it twice, when I look at the case file, all the evidence, I say all, and I'm speaking as a lawyer, they are not only damning, all of them goes in one direction. There is absolutely no contradiction from police officers and other witnesses." Those are the words of an influential member of this National Assembly, the Honorable Prime Minister. The words that he pronounced this morning. And it is very important to analyze those words in the context of the presentation of this bill. The Honorable Prime Minister makes reference to him having seen the case file. What is the meaning of a case file? And I observed the Honorable Prime Minister went across the recording, paused, went back, paused, looked at each shot. I must admit you were well dressed this morning, as you are now, so I enjoyed watching. But that was not the reason why I was watching you, sir. The reason I was watching is because what you were saying, cela m'a interpellé. Because then I saw you lift a file which was not in front of you, where you were reading from. I saw you lift another file and said, when I look at the case file, and then he held the file. So my question is, sir, what is the case file that he was referring to? Because the only case file I know, because he said he was speaking as a lawyer. As lawyers, you see, he's had a very successful career as a politician. And to glorify his successful career, he is now Prime Minister. Congratulations. I've spent more time at the bar practicing as a lawyer. So all lawyers, as he would know, what is a case file? A case file is in fact a police case file. If it is not, tell me the contrary when you have the time to intervene and clarify. Because right now, in my mind and in minds of the public, you said you saw the case file. And I equate case file with a police file. And you went as far as to say, I say all. I'm speaking as a lawyer. All the evidence. So he saw all the evidence. What is in a case file? In a case file, there lies evidence. It is not in the Prime Minister's file that you have evidence, it's in the police file. Therefore, if the police file has evidence, how the hell did it end up in front of the Prime Minister's hand? How? Therefore, it is logical to conclude that he has had access to the police file. If I'm wrong, forgive me. But this is what it says to me. Because he said, I saw all the evidence. He went on to say, there is absolutely no contradiction from police officers and other witnesses. Therefore, the Prime Minister has had access to witnesses' statements in order for him to say there's no contradiction. How can he have access to witness statements if it was not remitted to him by the Commissioner of Police? Think. I pause, I shudder, because this means that the general rule provided for in the Constitution that says that the role of the Commissioner of Police is not to be under the control of any authority, but to simply, if at all, take general policy issues. The Prime Minister, that's all he can do to the Commissioner of Police, general policy. But general policy does not mean that he can go and see what witnesses' statements contain. So, general policy does not mean that.
I got your point.
Good.
And
I tried to make it legible.
You are concentrating too much
on the Prime Minister?
The subject is you have a bill.
I'm coming and explaining, I'm connecting it now.
You've taken almost 5 minutes.
Very good. I've got 5 minutes extra because the Honourable Kolendavelu granted me that.
So I'm afraid.
Oh yes, he did. Oh yes. Oh yes. Oh yes. Oh yes.
I'm afraid you're wasting your time.
No, I'm not wasting my time. It's my speech.
Go directly to the bill.
I am being relevant.
My instruction, go directly.
You can't instruct me what to speak about. This is my speech, not yours. Now, as I'm saying...
Come on.
Come on what?
This is lack of respect to the chair.
I'm telling you...
I am giving you my ruling. You have to concentrate on the bill.
I am.
You have been talking too much on that point.
Okay.
Whether you have a point or not, the Prime Minister will reply to you.
Okay.
But you're concentrating too much on that point, and you keep on discussing with the chair.
So you understood, so I will move on, therefore.
Apologize for that first.
I apologize for whatever you want.
I am happy you apologize.
Do you want me to apologize for anything else? Tell me. I'll apologize as a series.
Apologize for what you did wrong.
Okay. In advance as well? Anything. Tell me.
Apologize to the leader of the opposition.
Oh, he's a good friend of mine. You're not. I don't have to apologize to a friend. He's a friend. I don't need to apologize. To you, I apologize, since you're not a friend. You are taking my time. You are taking my time.
Apologize and continue.
I'm not apologizing again. I've done enough of apology.
You have already apologized.
I've already done it. Okay, you love the word.
Go ahead.
Record it.
Go ahead.
Play it over and over again.
Oh, come on. Now you're going too far.
Apologize again?
I'll stop you. Mind your language, and you should know that you're talking to the chair, yes, and you have respect. Yes. Apologize once more.
Apologies. Happy? Thank you. So I am. So am I. So why do I connect the Prime Minister with this bill? Because he has an aversion, and he has expressed his aversion for the office of the Director of Public Prosecutions.
Express any aversion for the office of the DPP. In my answer to the question that was put to me this morning, I have only stated the facts with regard to workplace. But what is it? What you want? You are a barrister now. You want to?
That is explanation.
So the honourable member cannot say that I.
Are you the speaker? No. Are you the speaker? He is talking to the speaker? No. He's talking to the speaker. He looked at you. Apologize. You apologize. Yes. You better do that.
So, Mr. Speaker, sir, on the point of order, I have not expressed any aversion.
Oh, what is happening? Please, leave the house. Leave the house. Disrespect, leave the house. I am ordering you to leave the house. I am ordering you to leave the house. I am ordering you to leave the house. I am ordering you, Sergeant at Arms, do your work. Please, go take some fresh air. So there was a point of order.
I was saying, Mr. Speaker, sir, that I have not expressed any aversion to the office of the DPP or to the DPP himself. What I was replying to a question this morning, I was only stating the facts of the case.
So I heard this point, so don't refer to that. Please go to the bill.
I'm going to the bill. That was not a point of order. That's a point of explanation, and I take it. I will try to.
You have your own opinion.
I'm entitled to it.
You know, the Prime Minister has got the right to make a point.
I'm saying I'm moving on, sir.
I am the Speaker.
I'm moving on.
And you're doing the work of the Speaker.
I'm moving on.
You're eating your own time.
You are eating my time.
You are eating your own time.
So let's eat it together.
So this is the last warning I'm giving you. Try to behave yourself. This is the last warning I'm giving you.
Yes, sir. So let me now refer to a very important document. And here where I differ with the Honourable Colin Dabelou is as follows. You see, he goes on to explain that from his understanding, the DPP is not above the law, and he goes on to justify the Prosecution Commission, and he goes on to justify that there should be the possibility of having judicial review, and that was the whole purpose. But then again, you know, let me refer to your ruling, sir. To your ruling.
You don't have to refer to my ruling.
That's part of my speech.
You don't have to refer to my ruling. You don't have to refer to my ruling. Make your speech.
But that's part of my speech, sir.
Make your speech directly. Don't refer to my ruling. This is my instruction.
Okay.
Go and read the standing orders.
I will not refer to your ruling. I will not. So according to Erskine May, I'll refer to Erskine May. In any debate, a member is required to declare any relevant pecuniary interest or benefit of whatever nature, not only pecuniary, whether direct or indirect, that they may have had, may have, or may be expecting to have. I think that as a seasoned member of the bar and of this assembly, the Honourable Colin Dabelou should have declared his interest, since he has a matter pending before the ICAC. And I would agree with what's in Erskine May. Now, how many members on the other side have to declare their interest? So the issue is not, therefore, who can prosecute or who will not prosecute. That is not the issue. And therein, you see, when my late father used to say, in their madness there is method. Let me say what he meant by that. You see, the issue here is not who is entitled to prosecute, who is not. It's not that the issue. Because I agree with the Honorable Prime Minister that the DPP retains the right to discontinue proceedings. I totally agree that Section 72, subsection 3, B and C, je n'ai pas de problème avec. But the issue is, with the coming up of this law, let us go and break down for all to understand what happens. All members of government who have any inquiry pending against them at the level of ICAC will obviously have to face the law as it is today. The matter will have to be referred to the Director of Public Prosecutions. From memory, it's under Section 82 of the Prevention of Corruption Act. Because the authority that has le dernier mot, whether to prosecute or not, is indeed, under the actual law, the Director of Public Prosecutions. But with the advent of this law, it will no longer be a constitutional position, that of the DPP, that decides to institute proceedings. He will no longer have that power. He will no longer have access to the file. He will no longer have the right in this statute to call for the file. No, it will be a political appointee chosen by the Prime Minister with the stamp of the President and supposed consultation with leader of the opposition. Hello, I've decided this. There we go. Thank you. So with the advent of this new law, many will be saved by the gong. Through the operation of statute. Can you imagine, sir, what the Honorable Prime Minister is proposing? That if the DPP decides not to go ahead, to discontinue proceedings, to stop proceedings, he will have to give explanations, and there will have to be, he can even have judicial review. But if the Director General does not institute proceedings, no explanations. So if he does not institute proceedings against Honorable Colin Davelu, no explanations required, no judicial review, no aggrieved party. If he does not institute proceedings in the Molnupiravir matter, he does not institute proceedings in the Grand Bassin matter, in everything concerning whoever reported there. There are so many, I can't even remember them. The Kisnen matter, everything. You can't go for judicial review. If the Prime Minister is serious, why does he not return it to the DPP to be the sole authority to decide? He owes an explanation to the country. Why not? And when the Honorable Minister of Social Security comes up with recommendations internationally, I listened to her. She said supposedly what they were doing was under the cover of recommendations. Wrong. It has never been recommended that the DPP should be removed with that constitutional right to decide to prosecute, to institute proceedings. So what will happen, therefore? So right now, I'm happy that Honorable Colin Davelu he said clearly, and I will say those two things. Honorable Colin Davelu said clearly that for him, even if there is a provisional charge, the DPP, with this new proposed legislation, will have a right to intervene and take over. I agree with him. Because this is what the law says, because this is what authorities say. This is basically what is the proposition in the case I will quote, and those are the cases of Lee Wai-Chong versus ICAC, the case of Dvorsky versus Croatia before the European Court of Human Rights, and most importantly, the case of Assange of the European Court of Human Rights, which clearly state, very simply, that proceedings start from the moment that someone, in Mauritius at least, is provisionally charged. Proceedings start then. Therefore, if proceedings start then, I agree with Honorable Colin Davelu that the DPP will therefore be entitled to intervene from the moment there is a provisional charge and you can't stop him. However, where the problem lies, how can the DPP intervene in the blind, in the dark, when he does not have the file? He has no right to call for the file. Therefore, if the Prime Minister agrees with Honorable Colin Davelu, unless he disagrees, if he agrees with Honorable Colin Davelu que le DPP peut intervenir du moment où il y a ce qu'on appelle a provisional charge, that he clarifies that in the law. Make it clear that the DPP is entitled to intervene. At least if he doesn't want to clarify it, say it here for posterity, for Hansard to print it out, and for any superior courts later on to see the intention of the legislator was not to remove that right from the Director of Public Prosecutions. But if the Prime Minister refuses to, he will therefore confirm there's disagreement between him and Honorable Colin Davelu. If he refuses to clarify, he will confirm there's disagreement between him and Honorable Colin Davelu. Which is which? Deux sons de cloche au sein d'un gouvernement. But then, Honorable Colin Davelu talks about judicial review. In the case of Malhotra versus the DPP, this is a case that Honorable Colin Davelu should know, Honorable Obigadu should know, Honorable Ganou, who's not here, should know. In that case, it was clearly established that going for judicial review against the decision of the DPP, not to prosecute or to discontinue, all this, it is not an appeal decision, and the court cannot replace the DPP. It is only the process, the legality of the process that is being reviewed. This is judicial review. So let us not fool the people by making them believe that judicial review means that. Judicial review of a decision, and it is established by the Privy Council in the case of Moit. It does not mean that you can come and replace by another decision the decision of the DPP. It means that the law lords or the judges can only go as far as to decide on the legality of the process. That is judicial review. Et non pas comme une cour d'appel pour renverser la décision. Alors, Monsieur le Président, the Prime Minister, in my view, will have to explain to the people how, according to Section 66 of this bill, and this is something which is really worrying, Section 66 of this bill, where it says there is no need for reasonable suspicion. Section 66(1), that surveillance is allowed. Honorable Utim and other friends talked about that. And what is the description of surveillance, the definition of surveillance, which is at Section 66, 8B of this clause, of this bill. Surveillance means the continual act of monitoring, observing, listening to a person. Est-ce qu'on peut comprendre ce que le Premier ministre nous propose, Monsieur le Président? Monsieur le Premier ministre vient de l'avant avec le support de tous ses autres collègues, ministres et députés. Ils viennent de l'avant pour justifier qu'il est autorisé, sans avoir de raison, sans avoir de cause raisonnable, sans avoir reasonable suspicion, sans cette nécessité, parce que cela n'est pas précisé in Section 66, clause, subsection 1, without the authorization of a judge in chambers, it can go and surveillance with listening to someone. And where does it say here? From a public place, with the likely result of obtaining private information about that person or another person. Ça veut dire que you, them, us, people outside, they will be able to listen on to what we say and without reasonable suspicion. If the Prime Minister disagrees with me, why does he not, just like in the subsection 2, where the word reasonable grounds are used, why are reasonable grounds not used in subsection 1? Why the difference? So you go to the judge in chambers, you tell the judge in chambers, now I've listened, now I've monitored, now I have listened without your permission, and I want now your permission to go and investigate even further. Listen in even closer. This time you're going to have bedroom buddies. Even your bedroom they can come in now. But there, here, in a public place, you're walking along, they can record you. You're talking on the road, they record you. Without the permission, and it doesn't say here, for the purpose of preventing, detecting an offense. But il n'y a pas de reasonable suspicion now. It can be an innocent person. So they come and say, oh, I just want to detect. But one again, this is the Prime Minister who tells us that he does not want to do anything against human rights. But if he's serious, there's no reason not to believe him. Why doesn't he come and clarify his intention by adding the word reasonable grounds? Why does he not come and tell us that we have the right to apply for judicial review against the decision of the Director General? Do that at least. But then again, the whole ploy of this government, is to ensure that cases are stuffed in a drawer and that their prosecutions never happen at the eve of general elections. That is the ploy of this government. If Machiavelli wanted to know what was Machiavelli, but they could come here and see before them. We have fantastic people here that show us how to be better than Machiavelli. Under the guise of statutory provisions, they remove the DPP from the equation solely to block prosecution. That is why I say, when Erskine May says that Honorable Colin Davelu, my reading, should have declared his interest. Once upon a time, in 2015, he was Vice Prime Minister. And he rightly called me to order when he said I should have declared my interest and not put a question on the BAI affair. He was right, because I was a lawyer in there, and I bow to what he said. But if he said it to me, he forgets that he should give himself that advice? He forgets that then, when it suits him? Then he forgets. I look up to him. And I'm sad today that he has shown that for some bizarre reasons, he has forgotten the lessons he gave me. In those days, in 2015, I spoke to my late senior, Yusuf Mohamed, and he said, Ivan Colin Davelu was right. You should not have talked about this because you were a lawyer there. That is the respect a senior counsel had for another senior counsel. And today, où sont les principes? Où sont les leçons? La démocratie, on le détruit quand on le veut. La démocratie n'est pas nécessairement et simplement le droit de voter ou le droit d'exprimer son opinion. Mais ce n'est pas d'appoint the political friends in order to cover up cases. That is the point problem. And when you look at a document published, and I will conclude on that, published by the European Union, you see, whatever I'm saying is going to be entering one ear and then going out of the other ear. What I'm saying here today, this law should not even be in the hands of any Prime Minister, including the next. The next Prime Minister, Ramgoolam, has no right to have a law like that at his hands. Watch my words. He has no right to have this, because you know what? The difference between you and I, sir, the difference between you and I, friends, is that I am not someone who basically changes my tune because I'm in the opposition or government. I say that no Labour Party government is entitled to have a law like that. No MMM government, no alliance government should have this despicable act in their hands. It should be thrown out. It should be kicked out. And we undertake to throw it out, because when the European Union in the Venice, when it says in Strasbourg on the 15th of March 2011, what did it say in the Venice report? It says at page 6 of that report, the Venice Commission goes to talk about political interference in prosecution, like here. The report points out that that if modern Western Europe has largely avoided the problem of abusive prosecution in recent times, this is largely because mechanisms have been adopted to ensure that improper political pressure is not brought to bear in the matter of a criminal prosecution. The Commission points out that in totalitarian states or in modern dictatorships, criminal prosecution has been and continues to be used as a tool of repression and corruption. However, as the Commission states, the existence of systems of democratic control does not give a complete answer to the problem of politically inspired prosecutions. Mauritius is creating history indeed. It is not about political prosecutions. It is about political cover-up. Thank you very much.
Thank you, Mr. Speaker, sir, for giving me the opportunity to lend my voice to such an important piece of legislation. Mr. Speaker, sir, I have been listening carefully to members of both sides of the House, and I would say that at the very outset that I'm not a lawyer, so I will not be able to give any lecture in the House. However, one thing that I can say is the show must go on, so we need to clap, clap, clap for the shows that has been going on and on. Mr. Speaker, sir, as a young elected member of the House, I have some questions as well. But before coming to the questions, which I hope would be answered by members on the other side who have been very boldly putting questions towards our Honorable Prime Minister, the explanatory memorandum of the Financial Crimes Commission states clearly the why and the purpose of this bill, of the legislation. It states clearly that it is to provide for the establishment of the Financial Crimes Commission, which will be the apex agency in Mauritius to detect, investigate and prosecute financial crimes such as corruption offences, money laundering offences, fraud offences, the financing of drug dealing offences and any other ancillary offence. And when you go into details, into the clause, you can see that it's very well worked and very detailed as well, where it mentions about the chief legal advisor, the financial crimes such as corruption offences, money laundering, other offences which have been added as well. So my questions, before getting into the gist of the bill itself, Mr. Speaker, sir, is we just heard some members on the other side saying, putting questions about the role of the DPP and also questioning, but we just experienced comment justement noyer le poisson. So the honourable member which spoke right before me, he came with a statement, referring to the speech of the Honourable Prime Minister this morning answering a PQ with regard to his honourable colleague, Honourable Eshan Juman. So he came forward with questioning about the report, questioning about the documents being produced into the House. But what he fails to mention is that his colleague did accept that he personally posted on Facebook, and I quote from the same source, Honourable, he confessed, exactly, he confessed and he posted on his page, il m'a fallu que 5 minutes entre 11h et 11h07. Ce matin du 5 janvier pour entrer au port jusqu'à la rade où un navire débarquait du charbon sans que la sécurité m'aide. He confessed it, and there were all the proofs that were there to get him incriminated. So what was decided by the DPP? That there was no case.
I object.
And Mr. Speaker, sir, I'm not giving way. I'm not giving way.
On a point of order, the honourable member has no right to question a decision of the DPP unless she does so by substantive motion. That is the standing orders. She has no right to do so. None. That's standing orders.
The honourable member is not questioning the decision of the DPP. Go ahead.
Mr. Speaker, sir, I am only setting the background of the why today we need to vote this bill. This is my question towards the members of the opposition. This is my question that I'm putting forward to the members of the public which are following the debates, which is very much important to the House. So This is a simple case where a honorable member who said it openly, who confessed that he did something wrong. And alongside that, the Honorable Prime Minister did give figures of people who were convicted for the same thing. But the DPP found it right, deemed it right, this is setting the background, Honorable Member. He said there is no case. So I have more questions now. So you want us now to say that we can't challenge a decision. And Honorable Ivan Kolendavelu said it right. If someone has been raped and the DPP sees there's no case, no one questions the DPP. There is no one who can actually go and ask questions about what the DPP has done, whether it's right, whether it's wrong. Furthermore, Mr. Speaker, sir, allow me to put some questions forward. All the members which have been talking on the other side of the House, no one dares to mention about the coffers with $220 million. No one mentions this. This is good governance? And you want us to believe what you're teaching us in this House? Come on, as you said. And furthermore, what is more humiliating, what I heard right now, as a young parliamentarian, I'm not a seasoned parliamentarian, I'm not a lecturer, and I'm not a lawyer. But you can't come to the House and say, like, bedroom buddies. We, on this side of the House, we don't have tea parties with the director of ICAC. Someone called, what was the name? IM. Just go and check whose bed buddies it was. So please, you need to check it first. And Mr. Speaker, sir, $220 million dans les coffres. No one dares to mention it, not even Honorable Boulel. And we have some members on the other side.
Leave the House?
No,
yes, you're challenging my authority. You are challenging my authority. No excuse. Go out. Go out. You're looking for that. You're looking for that. I am ordering you to go out.
I want to stay, sir.
Go out. You continue.
Thank you. Thank you, Mr. Speaker, sir. And I have some more questions. Like, there's one political party who claims to be la tête haute, la main propre. Why are you scared today? Let me put the question forward. There was a bill which came to the House which was rejected for the electoral financing. Why did they refuse to vote for the bill? I have the question, where are the 10 millions provided to the MMM party by the BAI? We are talking about good governance today. This bill is here to really see all the loopholes that we have in our system, Mr. Speaker, sir. I have more questions regarding this one, which will make people understand why we need to support it. When we are talking about corruption, there's also bribery in it. The same honourable member who trespassed the port area was also the same member who gave 200 rupees or 100 rupees to a police officer. So it's all in the bill. So do we need to justify that and say, no, because you're in the opposition, we are just doing demagogy? No, these are facts. And it has been there in the Hansard as well, Mr. Speaker. So they are here coming to give us the lessons of good governance, bribery, corruption, les dollars, la main haute, la tête haute, la main propre. So they are the one giving us. And let me just add one more before moving to the bill. Macaroni. Let's talk about the macaroni as well, bribery. And they dare to come here and to give us lessons. And you know what is even funnier? The Honourable Member Shakil Mohammed just mentioned about declaring your interest when you're putting a question or when you are actually participating in a debate. So I think Honourable Joanna Béranger should have declared her interest in Omnicane Company before putting any question to this House. So the rules apply to them also. So Honourable Shakil Mohammed should have shared it avec ce consoeur. Voilà. Moving on to the bill right now, Mr. Speaker, sir, as I said it, les donneurs de leçons, they are everywhere once they are on the opposition seat. So, Mr. Speaker, sir, today it's a very important day as we are debating about the democracy, the transparency of our country, and we are talking about the financial sector. The Honourable Prime Minister and the Honourable Minister Siratan, as well as Honourable Ivan Kolendavelu, talked very well, extensively, giving more details about what is happening and also the powers of the ICAC as well. However, Mr. Speaker, sir, Honorable Shakil Mohammed questioned about the democracy. Let me just take you down to 2002 when the POCA was brought to the House. But prior to that, there was the Economic Crime and Anti-Money Laundering Bill in 2000, which had as object the establishment of an economic crime office headed by a director to investigate into suspicious transactions, money laundering, and serious economic. In 2002, when the Prevention of Corruption Bill was introduced, the then Prime Minister, by the then Prime Minister, Sir Anirudh Jagannath, the object was to strengthen the law on corruption and fraud by introducing a new corruption offences, which will be punished by severe penalties. Mr. Speaker, sir, however, in 2005, when the Labour Party government took office, there were like two amendments, one in 2005 and the second one in 2006. So the very first thing that the then Prime Minister did was abolishing the Appointments Committee of the ICAC, and during his second reading on September 2005, the then Prime Minister said, I quote, "The Appointments Committee of the ICAC was designed for specific functions and it was designed to guarantee the independence within the institution." I think we all agree that the Appointments Committee has failed to do that. In fact, the committee has not acted despite numerous requests being submitted to its chair. And the failure of this committee to act is one of the reasons for today's amendments. End of quote. Mr. Speaker, sir, this amendment clearly joins what the Honorable Ivan Kolenda-Bellew said, because at that very point in time, they already had someone to be appointed as the director of ICAC. And this is where the bedroom buddies enter for the Labour Party government. Mr. Chair, allow me to highlight also on the 142, section 142B and CD, prosecution. We have been hearing this in all spheres, whether it has been on the radios, whether it has been on the media, written or radios. They have been talking about the power of the DPP being, diminished and giving more power to the Commission. However, let me direct all the members present here that it is clearly stated in the section 142, where it says, I quote, following the conclusion of an investigation and the receipt of report under section 58, the Commission may institute such criminal proceedings as it may consider appropriate for an offence under this Act or declaration of Act. B, the institution of criminal proceedings by the Commission under paragraph shall be without prejudice to the powers, shall be, I repeat it, shall be without prejudice to the powers of the Director of Public Prosecution vested in him, to the exclusion of any other person or authority under section 72(3) B and C of the Constitution to take over, continue or discontinue such criminal proceedings. It boils down to the same question once again. If there has been injustice, if there has been anything which has been wrong, no one questions the DPP. No one can actually challenge the decision of the DPP. However, it stays the same, but the Commission has the right to bring forward new point of views, new ideas as well, and give a second chance to anyone who feels que son droit a été lésé. And also, as mentioned by Honorable Ivan Kolenda-Bellew, the DPP cannot be over and above the law. And we also know who has been the DPP in the past years and why. The question once again, why has the Honorable Member Eshan Juman been acquitted? Has no case against him by that then DPP. So this is our questions which the population is asking. Everyone wants to know the answer. So, Mr. Speaker, sir, as a conclusion right now, because I'm giving my remaining time to the Honourable Member Ivan Kolenda-Bellew, so I'm sharing my time with him. To conclude, Mr. Speaker, sir, this bill is a testimony of our commitment in transparency and democracy, Mr. Speaker, sir, and it is a visionary step towards an ethical society, a bill which should be over above politics, and it's paving its way for a safe investment state. Mr. Speaker, sir, I would once again say that we fully support the bill on this side of the House. Thank you for your attention.
Merci, Monsieur le Président. Si j'ai à résumer les débats et ce qui a été dit par celle qui m'a précédé, je citerai une citation de Honoré de Balzac. La fratrie n'émane jamais de grandes âmes. Elle est l'épanage des petits esprits qui réussissent à se rapetisser, encore plus mieux entrer dans la sphère vitale.
Allow me to interrupt you. Please withdraw that quotation. You don't ask me why. You withdraw that quotation, petit esprit.
Okay, I won't continue.
You will be the petit esprit in this case. Withdraw that.
Okay.
Withdraw that and you continue.
Okay.
Withdraw and you continue. If not, I'll stop you. The next one would be...
Okay, I withdraw.
Oh, okay.
I've said it twice.
Continue.
Monsieur le Président, un projet de loi très complexe avec des visées politiques très précises. Un projet de loi qui suscite beaucoup d'appréhension de plusieurs partenaires de la société civile. Et récemment, dans une de ses déclarations publiques, le Premier ministre lui-même a dit que ceux qui ont fait quelque chose à cacher ou ont fait quelque chose de mal, qui doivent avoir peur. La pertinence veut que tous ces acteurs de la société civile, les professionnels du barreau et extra-parlementaires montent au créneau pour dénoncer la politisation de cette mégastructure. Tout ce monde ne peut être des bandits financiers. Monsieur le Président, la question qui vient à l'esprit concernant la mise en place de la Financial Crime Commission et son agenda, est-ce qu'il s'agit d'assurer une plus grande coordination entre les organismes chargés de l'application de la loi, y compris le partenariat public et privé, pour lutter contre la criminalité financière, ou s'agit-il d'un moyen d'utiliser le Financial Crime Commission comme une arme par le biais d'une approche autocratique pour tout contrôler en tant que chef de l'exécutif en attaquant l'état de droit qui est basé sur le principe sacré de la séparation du pouvoir, l'exécutif, la législative et le judiciaire. Ou tout simplement faire en sorte qu'un garçon aux yeux bleus soit à la tête d'une telle superstructure pour surveiller de très près les opposants du régime. L'avenir nous dira. Monsieur le Président, en prélude à ce projet de loi, n'oublions pas quelques faits intéressants. Un rapide rappel de l'une des structures existantes, à savoir l'ICAC, sur qui 5 993 cas seulement, 127 cas ont abouti à des poursuites réussies, qui me pousse à dire que cette institution, qui devait fêter ses 20 ans d'existence, va peut-être disparaître dû à son palmarès très peu flatteur. Pourquoi l'ICAC n'a pas donné les résultats escomptés, en particulier la performance inapte de l'ICAC, pour prendre à partie que ceux qui se trouvent dans les sphères du pouvoir, tout simplement pas de procès pour les agresseurs de haut niveau. Monsieur le Président, des affaires très métisées qui n'ont pas vu l'issue, en particulier jusqu'à maintenant. Le Saint-Louis Gate, le Angus Road Gate, la poursuite bâclée du Menu Péravire, l'enquête sur les papiers de Kisnen, l'affaire Franklin, la fameuse tag party, l'octroi d'un bail à Dayo et Manger à Grand Bassin. Et il ne faut pas oublier qui est à la tête de l'ICAC, lui-même qui s'est fait tout petit pendant le procès du Privy Council concernant l'affaire Medpoint et son fameux volte-face, malgré l'explication tant expliquée par l'honorable Colin David. Monsieur le Président, si pour redire la lourdeur et lenteur administrative et être au nombre des instances régulatrices financières internationales, une telle structure englobant les différentes agences créées pour lutter contre le crime financier et la corruption est nécessaire, je dirais tant mieux. Mais cette mégastructure comprend plusieurs divisions, avec des attributions spécifiques, aura certes des conséquences majeures, avec l'abolition de plusieurs lois en vigueur dans la lutte contre le crime financier, mais pour aussi entraîner le démantèlement de plusieurs agences chargées de lutter contre la corruption, l'ICAC, l'Asset Recovery Investigation Division de la FIU et le Integrity Reporting Services Agency, et la création de plusieurs d'autres commissions. Monsieur le Président, la section 167 du Financial Crime Commission est très importante pour ceux déjà employés à l'ICAC et le département de la FIU. Il éprouve la frayeur l'angoisse, l'appréhension au triangle de réduit. La crainte de perte d'emploi dans ces agences mentionnées ne doit pas être minimisée, car déjà la perception que seulement ceux qui sont proches au directeur désigné sont rassurés de faire partie de cette nouvelle structure. Monsieur le Président, qui des high-profile cases recommencerait-il à zéro ou changer les enquêteurs? Le flou persiste. Ces fameux cas, Alvaro Sobrino, avec ses milliards douteux, qui a pu contourner les mailles des agences censées de traquer le blanchiment d'argent seulement parce qu'on lui a regardé dans les yeux. Qu'adviendra-t-il du Serenity Gate? Quitte d'autres high-profile cases qui sont des adversaires, qui étaient des amis et sont devenus adversaires du pouvoir en place. Par exemple, les signes, ces enquêtes, par tout ce que pourrait donner les pouvoirs au directeur général, connaîtront peut-être un fameux coup d'accélérateur avec les pouvoirs accrus. Si la loi est perçue comme la loi ad hominem, comme un expert constitutionnaliste l'a déclaré, bien sûr, pour celui qui vous hante les esprits de l'autre côté de la Chambre, car chaque mardi avec des questions plantées sur lui, et nul doute dans leur viseur, et il vous laisse croire qu'il sera encore persécuté. Il ne faut pas oublier le colorable device qui fut essayé dans le passé pour que le leader du Parti travailliste perde son siège au Parlement. Monsieur le Président, les différentes divisions de la Financial Crime Commission, leur composition devront avoir l'approbation du Premier ministre et donc seraient tous des nominés politiques dans leurs domaines respectifs. Il n'y a aucune indication dans ce projet de loi que la nomination se ferait dans la transparence ou par appel de candidature. Évidemment, dépendant du profil sur qui on enquête, est-ce que ces différentes divisions seront indépendantes ou answerable to who nominated them et n'ont pas utilisé l'organisme pour mener la vie dure aux opposants politiques. Monsieur le Président, je parlerai sur la nomination du directeur général. Sa nomination serait faite suite aux recommandations, comme dans le passé, au Premier ministre, au Président de la République, après consultation. C'est du benchmark, c'est du rubber stamping. Mais pourquoi pas avoir, comme auparavant, un appointments committee, ou plus loin, j'irai, le Legal and Judicial Commission, pour apporter plus de transparence et respect dans la nomination du directeur général. Le Financial Crime Commission sera sous le contrôle absolu d'un nominé politique en comparaison alors que le DPP est nommé par le Judicial and Legal Service Commission et son indépendance est assurée. Les qualifications qui sont dites pour être requises pour être directeur général du FSI donnent l'impression que c'est taillé sur mesure pour un très proche du régime qui se frotte déjà les mains. Quand la section 10 sous section 2 ressemble étrangement, je dis étrangement, au profil de celui qui déjà occupe un poste très important dans une des agences liées au combat de la lutte contre le crime financier et dont son palmarès est pas flatteur du tout. Une des attributions du Parliamentary Committee serait la termination of appointment of the Director General sous section 1A. Grosse négligence, irrégularité, mauvaise conduite, mais cela ne va jamais arriver. Quand le tiers-personne est nommé par le Premier ministre et avec la majorité de 5 sur 4, il serait toujours en position majoritaire. C'est de la poudre aux yeux. Le Premier ministre reste au final la personne qui dirigera le Financial Crime Commission. Monsieur le Président, les pouvoirs du directeur général, la section 6 du projet de loi donne tous les pouvoirs d'arrestation si le directeur général soupçonne une personne d'être impliquée dans un crime financier ou d'autres délits tombant sous la loi du FCC ou la Declaration of Assets Act. Donc le rôle du DPP est effacé au profit du directeur général désigné de la Financial Crime Commission. Contrairement avec l'ICAC, il fallait absolument, et je dis absolument, passer par le DPP pour entamer des poursuites. Monsieur le Président, il n'y a aucun doute que ce projet de loi vise à créer un organisme parallèle avec le DPP, une façon déguisée d'usurper et de réduire le rôle et le pouvoir du DPP, qui, ne l'oublions pas, est protégé par l'article 72 de la Constitution. En référence à ce qu'a dit le Premier ministre ce matin au DPM-QT, il faisait référence au communiqué de l'Office du TPP, particulièrement au cas où il y avait des communiqués, l'appel Medpoint au Private Council, le State Trading Corporation against Anil Betu et Navin Ramgoolam, et le no further action dans le cas de l'honorable Chanjuman et la DPP. Et donc, c'est clair, c'est pourquoi on veut museler le DPP, on ne veut pas qu'il y ait son droit à la parole. Est-ce la façon du gouvernement de régler son différend avec le DPP en lui enlevant certains de ses prérogatives? Je n'ai pas la réponse, mais la réponse viendrait après l'institution du Financial Crime Commission. Monsieur le Président, quel est le but de donner tout ce pouvoir au directeur général? Ils veulent avoir une main mise sur la charge provisoire. Ils ne veulent pas que le DPP ait un droit de regard. C'est la fin de l'état de droit. La Financial Crime Commission va elle-même décider d'enquêter et poursuivre une situation insectueuse et partisane. Le pouvoir d'arrêter ceux dont il sera ordonné de le faire et de ne pas arrêter ceux qu'ils ne veulent pas arrêter. Le gros danger, qu'il sera possible d'arrêter facilement des opposants politiques et d'éleger des charges provisoires contre eux. Déjà, sans le Financial Crime Commission, on a vu comment, du jour au lendemain, l'ancien CEO du Mauritius Telecom, qui était des bad buddies, s'est retrouvé au centre de plusieurs enquêtes. Et maintenant, avec tous ses pouvoirs, je crains pour la liberté de tous. La Financial Crime Commission ne sera pas redevable envers personne, selon le texte de loi. Mais on n'est pas dupe. Bien sûr, he will have and he will be answerable to his master, who willfully and purposely nominated him. Monsieur le Président, Mr. Speaker, sir, such autocratic approach raises the fundamental question about the balance of power and the safeguarding of democratic principles, not only from the opposition and the free press, but also from the lawyers and civil society at large. The privileges between clients and barristers, major concerns are being raised. Mr. Speaker, sir, the conflict between the DPP's office and the office of the Commissioner of Police paints a concerning picture with the ICAC sandwich. Le timing de ce loi est indécent et maladroit, car déjà une affaire est en cours entre le CP et le DPP. Il aurait fallu attendre que cette affaire soit entendue. Monsieur le Président, laisse-moi parler maintenant. J'ai eu l'occasion d'écouter l'expertise d'un senior counsel sur le Defunct Prosecution Commission, qui ne se rappelle pas de l'urgence d'introduire ce projet de loi à la veille de la fête de Noël, mais qui ne s'attendait pas à la réplique de l'honorable Xavier Duval, alors député Prime Minister, et démissionné. Aujourd'hui, nous assistons aux manœuvres subtiles d'introduire le Defunct Prosecution Bill de manière déguisée par le backdoor, mais de manière encore plus dangereuse. Le Financial Crime Bill est présenté comme une loi ordinaire qui nécessite une majorité simple de vote, alors qu'elle a une touche constitutionnelle. Voilà le colorable device qui est servi, car ceux en faveur de ce projet et la loi semblent avoir bien retenu la leçon de l'épisode Public Prosecution Bill de 2016, où il fallait avoir 3/4 de la majorité des votes. La contestation, si on fait, pourrait prendre le même temps que le cas Sigam, et entre-temps, beaucoup de personnes subiront les frais. Vous, mes collègues de l'autre côté de la Chambre, prenez vos responsabilités, car rien ne vous sauvera quand l'intérêt des autres primeront et vous serez sacrifiés sur l'autel. Demandez à l'honorable Colin Davelou, le PPS d'Alia en sont des exemples. La roue tourne. Mr. Speaker, there shall be 3 committees: Parliamentary Committee, Operation Review Committee, National Coordination Committee. Where is independence and saying there is a check and balance? It is inexistent when they are all under the grip of the one person who will nominate them and the recommendation, obviously. Mr. Speaker said, I will just go through certain aspects of the bill amendments to legislation. Amending the Bail Act has only one motive. the Director General of the Financial Crime Commission is to be given power to restrict movement of an accused who has been investigated or probably charged under the Financial Crime Commission. This is a very dangerous authority, given in the hands of a political nominee. And make no mistake, will most certainly be used against political opponents.
Try to conclude.
So, the second amendment contains the Courts Act, and the third amendment is the Criminal Act, all of which the Director General of the Financial Commission are being given authority to intervene before it was only the Commissioner of Police and the DPP. Pour terminer, il n'est pas surprenant. Je fais une conclusion d'abord. En conclusion, je ne me perds pas d'illusion à l'indépendance de cette nouvelle entité, surtout quand il y a plusieurs enquêtes sur des personnes au pouvoir qui attendent d'être dépoussiérées, mais dont leur sort sera maintenant entre les mains d'un nominé politique avec des pouvoirs extraordinaires. De ce fait, je voterai contre ce projet de loi qui va à l'encontre même de la justice universelle, comme dirait ce fameux dialecte de notre langue créole, avant Tinaïkak, maintenant FSC, blanc bonnet, bonnet blanc. Merci.
Monsieur le Président, la société civile a à de nombreuses reprises fait ressortir que le trafic de drogue ne recule pas suffisamment. Et cela malgré les gros efforts de saisie et d'interception des drogues par la police. Les institutions internationales, les forces de l'ordre et la société civile sont unanimes à dire qu'il faut s'attaquer au financement de ce fléau pour faire ralentir le trafic de drogue et de surcroît toute autre activité illicite reliée à ce trafic. En ce faisant, Monsieur le Président, a la possibilité pour les trafiquants de jouir des revenus de ce business illicite. Dans trop de cas, ces trafiquants ont démontré qu'ils ont plus de moyens et peuvent, avec leur argent, avoir une longueur d'avance sur les forces de l'ordre. La corruption et le blanchiment d'argent reliés à ce trafic nécessitent une réaction musclée. Et notre Premier ministre introduit le Financial Crime Commission Bill en s'alignant sur les pratiques internationales. Monsieur le Président, en ce qui concerne le comité parlementaire de l'ICAC, il est nécessaire de répondre aux leaders de l'opposition et la présidente du comité parlementaire veut faire ressortir que le comité est constitué de 5 membres du gouvernement et 4 membres de l'opposition, mais que les 4 membres de l'opposition ont démissionné sans aucune justification. Pour que le comité siège, il faut un quorum de 5 membres. L'opposition nous a privés de ces 4 membres. Des sièges qui sont restés vacants puisque le leader de l'opposition lui-même ne remplit pas ses vacances. Le comité a eu à fonctionner dans ces conditions. La présidente du comité parlementaire de l'ICAC ne perçoit pas de privilèges à contrario du président de la PAC. C'est-à-dire pas de rémunération, pas de voiture, pas de bureau et pas de secrétaire. La provision de l'APOCA, qui donne la possibilité au comité parlementaire de faire un rapport de recommandation, n'est plus applicable depuis l'amendement qui a été apporté à l'APOCA par le régime PTR-PMSD en 2006. Donc, Monsieur le Président, c'était nécessaire de rectifier ces faussetés qui ont été dites plus tôt. En ce qui concerne, Monsieur le Président, le projet de loi, il semblerait que beaucoup appréhendent un potentiel abus de la Financial Crime Commission et pensent que cela dérogera à nos principes et valeurs de démocratie libérale. Dans le cas présent, comment est-ce que les provisions de cette loi dérogent-elles drastiquement de ces valeurs? Je me suis efforcée à étudier et à comprendre l'esprit de cette loi et de la nouvelle structure institutionnelle qui nous est proposée. Je suis arrivée à la conclusion que l'esprit de cette loi s'aligne à celle du principe de séparation du pouvoir dans le cadre d'une démocratie libérale. En tant que membre du comité parlementaire de l'ICAC, je peux témoigner qu'il nous a été rapporté à plusieurs reprises que le temps que demande la prosécution a été décrié par les membres de l'institution elle-même. Ils pensent que le temps de réaction de la poursuite dans le domaine d'activité de la corruption et du crime financier affecte grandement l'efficacité de l'ICAC. Et pour témoin, les membres qui ont démissionné du comité parlementaire de l'ICAC ont souvent participé à ces débats avec nous au sein du comité. L'honorable Farad Oumir a tout à fait raison. Le nombre de cas que l'ICAC qui ont abouti à la prosécution est insatisfaisante. D'où la nécessité de la Financial Crime Commission d'avoir la possibilité d'intenter la poursuite quand nécessaire. Monsieur le Président, ceci est cohérent avec la réintroduction du Operations Review Committee, qui aura pour fonction d'introduire un nouvel Internal Accountability Mechanism. C'est à mon tour, Monsieur le Président, de citer quelqu'un. Ce n'est pas Voltaire, pas Machiavel, pas Honoré de Balzac, mais Montesquieu. Puisque nous parlons de séparation de pouvoir et de principes et valeurs démocratiques. Pour qu'on ne puisse abuser du pouvoir, il faut que, par la disposition des choses, le pouvoir arrête le pouvoir. Le Operations Review Committee aura pour mandat de revoir et questionner tous les cas qui datent de plus d'1 an. Les cas où les suspects sont restés en bail pendant plus d'1 an, mais aussi n'importe quel cas qui est sous investigation. L'ICAC a souvent été qualifié de washing machine, de cover-up machine, et la raison principale étant le manque de internal mechanism, Monsieur le Président. Permettez-moi de rappeler que ce Operations Review Committee est essentiel pour rétablir la confiance. Un comité qui sera présidé par un ancien juge ou un cadre de la profession légale. Ceci est aligné avec l'objectif qui est d'accélérer la procédure de la poursuite afin de résoudre les cas dans un temps raisonnable. Ce comité a le pouvoir de questionner et de rendre accountable n'importe quel officier de la Financial Crime Commission, y compris le directeur. Ils auront droit à un mandat de 3 ans qui donne suffisamment de temps pour travailler sans être vulnérables aux pressions externes. Ce internal mechanism, Monsieur le Président, permet d'ajouter un additional accountability mechanism, mécanisme qui a été enlevé par le précédent régime. Quand le leader de l'opposition affirme que cet organisme n'aura only an advisory role, c'est une déclaration qui ne prend pas en considération que la loi prévoit un secrétaire nommé pour assurer l'implémentation des décisions et non des conseils du comité. Donc c'est assez évident que le comité, le Operations Review Committee, n'a pas un advisory role, c'est un decision-making body. L'introduction de la Financial Crime Commission dans le territoire de la poursuite semble susciter beaucoup de réactions. Cependant, cela semble être de façon injustifiée, être perçu comme une attaque au pouvoir du DPP. Le DPP garde le upper hand. Il peut faire valoir son pouvoir constitutionnel qui est de take-over, continue ou discontinue criminal proceedings du Financial Crime Division. Il peut faire valoir son pouvoir au Financial Crime Division de la Cour suprême. S'il a des raisons sérieuses de douter de l'intégrité de l'enquête et de la poursuite pour la Financial Crime Commission, il peut aller de l'avant. La section 142 n'affecte pas le pouvoir constitutionnel du DPP, mais libéralise le domaine de la poursuite. J'interprète que le DPP lui-même est un safeguard contre la Financial Crime Commission dans ce cas. Il maintient son rôle de safeguard. Monsieur le Président, l'autre aspect sur lequel je voulais mettre l'accent, c'est l'introduction, Monsieur le Président, du Private-Public Partnership et l'introduction de la protection des whistleblowers. Et cette protection des whistleblowers va devoir suivre les protocoles établis par les Nations Unies. L'apport du secteur privé et la considération donnée à ce secteur démontre la démarche libérale de ce projet de loi. L'esprit de cette loi permet au pouvoir d'être un plus grand rempart au pouvoir. À la différence que les mécanismes mis sur pied se trouvent plus au grassroots et tout au long du procédé de la Financial Crime Commission. Monsieur le Président, s'il y a une erreur que je pense que tout gouvernement commet, ce n'est pas celle de la poursuite, mais c'est celle de ne pas suffisamment élaborer et d'investir sur l'éducation et la sensibilisation contre la corruption et le crime financier. La lutte contre le crime financier et la corruption, c'est avant tout un changement d'attitude de la société. La répression, à elle, ne suffit pas. La protection des whistleblowers, à elle, ne suffit pas. Il faut qu'il y ait une culture de dénonciation et de refus de la corruption et du crime financier. Il faut qu'avec l'introduction du partnership entre le secteur privé et le secteur public, qu'il y ait beaucoup plus de partenariats pour le travail d'éducation et sensibilisation. Un exemple, c'est les Social Attitude Surveys qui doivent être réintroduites dans notre système. Ce sont des surveys qui mesurent la confiance dans les institutions, mais aussi la culture publique prédominante dans la société. Nous ne parlons pas de culture religieuse ou ancestrale, mais d'attitude face aux gros problèmes de société. Comme par exemple, comment est-ce que la population, PSO à la corruption, réagit face à la corruption, au trafic humain, au trafic de drogue. Ces données sont essentielles pour une campagne de sensibilisation et d'éducation efficace. Une campagne qui changerait l'attitude négative prévalente face à ces problèmes. Monsieur le Président, pour conclure, je pense que l'esprit de cette loi est loin d'être celle d'attaquer la séparation de pouvoir. Mais je pense que c'est une réaction musclée à un problème qui engangrène nos institutions, notre société et notre économie. Je constate une libéralisation de la participation de plus de membres de la société civile et du secteur privé dans le procédé de la Financial Crime Commission. Cependant, toute bonne intention ou super institution ne sera être efficace et avoir le résultat espéré sans un changement d'attitude profond dans notre société. Celle-ci ne peut que se faire à travers l'éducation et la sensibilisation. Monsieur le Président, j'ai terminé.
Puis Joanna Béranger.
Yes. Nous sommes tous ici d'accord sur une chose. La lutte contre les crimes financiers nécessite une structure plus efficiente. Et c'est bien d'ailleurs la raison pour laquelle l'un de mes collègues avait posé la question de savoir quand est-ce que le Financial Crimes Commission Bill allait être présenté au Parlement. L'honorable Siratan avait fait référence à cela avant moi. Et oui, bien évidemment que la question avait été posée. Parce que justement, nous sommes tous en faveur d'une structure plus efficiente pour combattre les crimes financiers. Mais c'est justement le contenu de cette loi et la méthode utilisée par le gouvernement pour la faire voter qui pose problème ici. D'abord, parce que ce projet de loi est voté en 4e vitesse, pendant que toute la population a la tête dans les activités de fin d'année. Et ensuite, parce que c'est un monstre qui est en train d'être créé à travers cette méga structure qui regroupera sous le même toit l'ICAC, l'Asset Recovery Investigation Division et l'Integrity Reporting Services Agency. À la tête de cette super structure, un super homme avec des super pouvoirs qui est mis sur un pied d'égalité avec le commissaire de police et le DPP, mais qui est nommé par le Premier ministre. Et il est bien là le problème. Bien que la section 4 veuille prétendre à un semblant d'indépendance, la section 10 prévoit, elle, que le directeur de la Financial Crimes Commission sera nommé par le Premier ministre. Donc le directeur général sera redevable envers le Premier ministre et non pas envers les contribuables, ni envers qui que ce soit d'ailleurs. C'est d'ailleurs le Premier ministre qui décidera aussi de son salaire, et on sait que jusqu'à l'heure, le salaire du directeur de l'ICAC n'a toujours pas été officiellement révélé, malgré plusieurs questions à ce sujet. Et il faut dire que c'est quand même le comble pour une institution qui cherche à promouvoir la transparence. Ce sont donc ici les mêmes erreurs qui se répètent, qu'il s'agisse du semblant de redevabilité, et ici c'est uniquement envers le comité parlementaire que cette commission serait redevable, mais on sait que les pouvoirs du comité parlementaire sont très minimes, et d'ailleurs, comme l'a rappelé le leader de l'opposition un peu plus tôt, le comité parlementaire actuel n'a pas siégé depuis mai. Donc ce comité parlementaire a été inutile et c'est certainement d'ailleurs la raison pour laquelle son existence a été maintenue et n'a pas été améliorée. Ou alors qu'il s'agisse de la méthode de nomination du directeur, les mêmes erreurs sont en train d'être répétées au lieu de rendre plus efficiente l'institution chargée de lutter contre la corruption. La nomination du directeur aurait donc dû être faite soit par consensus des 3 personnalités de l'État, les 3 plus importantes que sont le président, le leader de l'opposition, le Premier ministre, comme c'était le cas quand l'APOCA fut adopté en 2002, ou à la limite par le Judicial and Legal Services Commission, comme c'est le cas pour le DPP, ce qui assure donc son indépendance. L'autre problème est bien évidemment la trop grande concentration de pouvoir entre les mains du directeur général de la Financial Crimes Commission. Le projet de loi donne à la Commission le pouvoir de détecter les crimes financiers à travers la section 6, de faire des enquêtes, de procéder à des arrestations, d'initier des poursuites sans passer par le bureau du DPP, selon la section 142 alinéa 1A, et même de contester ou pas la liberté conditionnelle. Mais ce sera quoi la prochaine étape? Il ne reste plus qu'au MSM de créer son propre tribunal, d'y nommer quelques agents pour y siéger, 2-3 jackets verts, comme on les appelle ces jours-ci, et contrôle tous eux de même. Il n'y aura plus de limite. Ce projet de loi permet une concentration de pouvoir d'enquête et de poursuite entre les mains d'une même autorité, ce qui est totalement contraire à la séparation des pouvoirs et à l'esprit même de la démocratie. Et d'ailleurs, si je ne me trompe pas, à travers le Select Committee qui avait été mis sur pied pour proposer le premier draft de l'APOCA, qui avait été d'ailleurs fait mention un peu plus tôt par l'honorable Colin Navelou, tous ceux qui y faisaient partie, y compris l'honorable Colin Navelou, avaient insisté sur le fait que tous les dossiers devaient aller au bureau du DPP et que l'ICAC ne devait pas enquêter et poursuivre. Mais ça, étrangement, l'honorable Colin Navelou n'en a pas fait mention. Ça a été complètement mis de côté. Je me demande qu'est-ce qui a changé depuis. Ce n'est pas pour rien qu'au moment de la création du bureau du DPP en 1964, l'expert constitutionnel de Smith avait souligné l'importance de protéger la justice criminelle en isolant tout le processus de poursuite des considérations politiques du pouvoir exécutif. Monsieur de Smith n'était pas un idiot, je pense. Il avait certainement des raisons évidentes pour lesquelles il avait dit cela. Actuellement, on le sait, c'est la police ou l'ICAC qui détecte, qui enquête, et le DPP initie les poursuites en cours. Et c'est là le rempart contre les abus. Le DPP s'assure de vérifier si l'accusation tient la route ou pas. Le DPP a la compétence, a l'expérience, a l'indépendance pour cela. Jusqu'ici, cette provision permettait donc au bureau du DPP d'agir comme un contrepoids face aux excès et manquements de la police, de l'ICAC, de la FIU, etc. Et on sait combien ils sont nombreux, ces manquements, malheureusement. Mais voilà qu'il est ici concurrencé par les pouvoirs du directeur général de la Financial Crimes Commission, qui devient une sorte de DPP déguisé en ce qu'il s'agit des crimes et délits financiers. Et le Premier ministre avait fait mention un peu plus tôt des recommandations de la FATF et de la SAMLAG. Mais nulle part, il n'est écrit que ces institutions ont préconisé que les pouvoirs du DPP doivent être concurrencés par ceux du directeur de la Financial Crimes Commission. Et nulle part, il est écrit que la Financial Crimes Commission doit pouvoir enquêter et poursuivre ou ne pas poursuivre. L'APOCA prévoyait spécifiquement dans l'article 47 que l'ICAC doit se tourner vers le DPP pour les affaires qui ne seront pas poursuivies après l'enquête préliminaire. Cette disposition n'existe plus. Pourquoi? Pour permettre de glisser tranquillement les dossiers dans les tiroirs sans que personne ne le sache et surtout sans que le DPP ne demande de poursuivre l'affaire. Pour s'assurer que le DPP ne puisse pas demander de poursuivre l'affaire. Et on sait qu'ils sont nombreux les dossiers où les membres du gouvernement sont mis en cause et qui dorment dans les tiroirs de l'ICAC. Ils ont été mentionnés avant moi d'ailleurs. Donc ce geste de faire disparaître l'obligation d'informer le directeur des poursuites publiques des affaires qui ne seront pas poursuivies en dit long sur les intentions de ce gouvernement et sur le futur fonctionnement de la Financial Crimes Commission, qui n'aura donc plus besoin de signifier le DPP qu'il n'y aura pas de poursuite sur certains dossiers. Donc, bye-bye l'affaire Angus Road, bye-bye l'affaire Kisnen, bye-bye l'affaire Pack and Blister, bye-bye Bet 365, Sobrino, Stag Party, Molnupiravir. On n'en entendra plus parler. La Financial Crimes Commission se dépêchera de clore ces dossiers sans aucune justification et sans aucune redevabilité. Et c'est comme ça que le gouvernement veut combattre la corruption. Et pourtant, même le Courts Act insiste sur le fait que tous les cas envoyés à la Cour intermédiaire doivent être référés par le DPP. Et mis à part les cas où il a délégué ses pouvoirs, tous les dossiers doivent être soumis au DPP pour sa décision de poursuivre ou pas. Plusieurs lois, y compris l'ICTA, précisent que le consentement du DPP est obligatoire sine qua non pour avoir l'assurance justement que des poursuites inappropriées n'aient pas lieu. Pourquoi déroger à cela? D'autant plus qu'ici, il s'agit d'infractions très graves comme la fraude, la corruption, le blanchiment d'argent, la cybercriminalité, le trafic de drogue, entre autres. Il ne reste donc au DPP que le pouvoir d'arrêter une poursuite abusive. Mais encore faut-il qu'il ait accès au dossier, encore faut-il qu'il ait accès aux informations. Et ce projet de loi cherche donc à contourner la section 72 de la Constitution à travers une simple loi. En clair, le gouvernement cherche à diminuer le rôle et l'importance du DPP. Pourquoi? À qui profite le crime ici? Au gouvernement, évidemment. Le projet de loi empiète sur les pouvoirs de poursuite d'une instance indépendante comme le bureau du DPP, pouvoir garanti par la section 72 de la Constitution, pour ainsi créer une institution pouvant initier des poursuites sous le pouvoir de l'exécutif. Donc, quelle est évidemment la crainte de tout un chacun? La crainte est bien évidemment, au vu des pratiques du gouvernement, la persécution des opposants politiques. La crainte est que cela ouvre la voie à des abus de pouvoir envers tous ceux et celles qui n'approuvent pas la politique du MSM. La crainte, ce sont les arrestations arbitraires basées sur des charges provisoires bancales. La crainte, ce sont les détentions prolongées en prison. La crainte, c'est la saisie des avoirs d'un suspect. Et le temps que cela prendra pour que le DPP arrête une poursuite abusive, l'atteinte à la réputation de la personne sera déjà faite. Et ce sont des droits fondamentaux qui seront bafoués entre-temps. La crainte, c'est aussi le risque de conflit entre les institutions, puisque, comme je le disais, ce projet de loi met la police, la Financial Crimes Commission, le DPP sur le même niveau d'autorité. Et l'on sait qu'il y a actuellement un cas devant la Cour, justement, pour définir qui, entre le commissaire de police et le DPP, a le pouvoir de poursuivre et de libérer des suspects sous caution. Mais voilà que le gouvernement se dépêche de venir avec cette loi, méprisant ainsi complètement l'autorité de la Cour. Et il faut dire que c'est la première fois que l'on voit une telle situation, que l'on assiste à une crise des deux institutions peut-être les plus importantes du pays. Pour le bien de la démocratie du pays, il aurait fallu une bonne relation, une coopération, un respect mutuel entre ces institutions. Mais c'est tout le contraire qu'on voit malheureusement. Donc le risque ici est clair, que l'on voit encore le DPP devoir passer son temps à arrêter les poursuites qui ne tiendraient pas la route et à devoir répondre aux objections de la Financial Crimes Commission, comme c'était le cas tout dernièrement entre le commissaire de police et le DPP, ce qui a mené au cas en cours, justement. Ce serait une perte de temps, et qui dit perte de temps, dit perte d'argent pour les contribuables, démocratie affaiblie et citoyens lésés dans leurs intérêts. Parmi les super pouvoirs qui seront entre les mains de ce nominé politique, j'aurai malheureusement pas le temps de venir sur tous ces pouvoirs, mais il y a les pouvoirs de surveillance permettant l'intrusion dans la vie privée des Mauriciens et Mauriciennes et le pouvoir d'interception des communications à travers la section 66. Et ce, aussi longtemps que la Commission le voudra. C'est encore une fois le manque de garde-fous qui effraie. Le manque de garde-fous pour s'assurer que les moyens utilisés soient proportionnés et que le droit à la vie privée, qui est un droit constitutionnel, soit préservé. Il est donc inconcevable, à notre sens, de mettre autant de pouvoir entre les mains d'un nominé politique. J'aimerais dire quelques mots en troisième lieu, et ce sera ma dernière partie. concernant l'emploi des personnes travaillant pour l'ICAC, la RID et l'ISA. Et cela concerne la section 167. On le sait, ce sont les personnes employées par la Financial Crimes Commission qui feront les enquêtes. Et dans la section 167, on apprend que les personnes employées par les institutions concernées, c'est-à-dire l'ICAC, la RID et l'ISA, se verront transférées sous la Financial Crimes Commission selon les mêmes termes et conditions actuelles. Jusqu'ici, tout va bien. Mais la sous-section 5 vient dire que l'emploi de ces mêmes personnes sous la nouvelle commission prendra fin après 180 jours. Ensuite, sous la sous-section 6, il est précisé qu'elles pourront être employées de nouveau selon les mêmes conditions qu'avant ou selon de nouvelles conditions. Cela signifie que la commission, après avoir permis à tous ceux et celles qui ont été transférés sous son autorité de garder leur emploi, après 180 jours, la commission aura la liberté de décider qui restera et qui ne restera pas, sans aucune justification. Quelle est l'intention ici? Pourquoi mettre fin au contrat de travail de ces personnes pour ensuite les embaucher de nouveau, embaucher certaines personnes de nouveau? Est-ce qu'il s'agit là d'un filtrage pour pouvoir contrôler aussi les employés de la commission et s'assurer que ceux et celles qui y travaillent seront dociles et répondront aux ordres de la cuisine? Je ne vois nulle autre explication ici. S'il y en a une, je voudrais bien qu'on me la donne. Il n'y a aucun critère dans la loi définissant ceux qui resteront ou ceux qui ne resteront pas, et la commission n'a besoin de donner aucune raison. Elle n'a pas besoin de dire pourquoi elle met un terme au contrat de certains employés, ce qui ne respecte absolument pas l'esprit du Workers' Rights Act, dont le but est évidemment de protéger les droits des travailleurs. Et ce raisonnement est valable également pour la section 7.5a, où il est mentionné que, ouvrez les guillemets, on the advice of the Prime Minister, donc sous recommandation du Premier ministre, le président de la Financial Crimes Commission peut mettre fin au contrat d'un commissaire pour breach of trust. C'est un terme qui est habituellement utilisé dans le cas des entreprises où il y a une relation employé-employeur, et comme l'a fait d'ailleurs ressortir le leader de l'opposition. Mais quelle indépendance auront ces officiers s'ils sont ici sous la perpétuelle menace de perdre leur emploi? Et je me demande ici quelle pourrait être la raison d'une rupture de confiance. Rupture de confiance entre qui et qui? Est-ce qu'il y aurait rupture de confiance parce qu'un commissaire ferait fi des ordres de la cuisine? Qu'on nous explique quels sont les cas qui pourraient être assimilés à une rupture de confiance. Ce qui paraît clair en tout cas, c'est que la commission a un pouvoir absolu de hire and fire et que ceci est contraire à la philosophie du Workers' Rights Act. Je terminerai en disant que le gouvernement avait là l'occasion d'améliorer le projet de loi actuel, de créer justement une structure plus efficiente en venant de l'avant avec un projet de loi moderne, prenant en considération la complexité et l'étendue des crimes financiers à l'échelle mondiale, prenant en considération aussi les nouvelles technologies et surtout les bonnes pratiques de transparence et d'indépendance. Mais au lieu de cela, nous avons devant nous un projet de loi qui ne respecte ni le peuple, ni la Constitution, ni l'État de droit, et c'est bien la raison pour laquelle nous ne voterons pas pour ce projet de loi et que nous la révoquerons une fois au gouvernement. Merci.
Thank you. Monsieur le Président, après le discours, ou dirais-je, le show de l'honorable Mohamed un peu plus tôt dans la Chambre, je pensais que l'honorable Béranger aurait commencé son discours par déclarer ses intérêts par rapport à Omnicaine, mais hélas. Et je reviendrai à ces propos un peu plus tard dans mon discours. Mais, Monsieur le Président, allow me to start the speech on the Financial Crime Commission with this quote from a report which has been recently published by the Deloitte Group International. I quote, "There is growing consensus that the current global framework for fighting financial crimes is not as effective as it could be. and that more needs to be done at the international, regional, and national levels to help identify and stem the flow of illicit finance and activity which supports some of the worst problems that the society is confronted to today, including terrorism, sexual exploitation, slavery, modern forms of slavery, wildlife poaching, and drug smuggling, unquote. Mr. Speaker, sir, it is an undeniable fact that financial crimes largely contribute to societal ills and verily threaten the financial stability and financial inclusion of any nation. This is why, Mr. Speaker, sir, I am grateful to have the opportunity to be able to bring my humble contribution to the debates brought by the Honourable Prime Minister this bill tonight, the Financial Crime Commission bill. On the global map, the very objectives of the Financial Action Task Force, the FATF, revolve around ensuring effective implementation of legal, regulatory, and operational measures for combating money laundering, terrorist financing, and other related threats to the integrity of the international financial ecosystem. And in this very respect, the FATF has developed a series of recommendations, and as mentioned earlier by Honourable Sihatan and the Honourable Prime Minister, the Mauritius being part of the Eastern and Southern Africa Anti-Money Laundering Group, the ESAMLAG, Mauritius has been called to adopt and implement the 40 recommendations of the FATF and to apply anti-money laundering measures to be able to combat the financing of terrorism, and as well as to implement any other measures to be able to ensure that the multilateral agreements and initiatives relevant for the prevention and control of laundering from proceeds of serious crimes and financing of terrorism, as well as proliferation of weapons of mass destruction. Mr. Speaker, sir, I will not go again through the details of the past reports of the FATF, as the Honourable Prime Minister has extensively spoken about same. But yes, as he said earlier in the House, from the fait accompli which the GM inherited at the time, and the failure of the former regime to engage in remedial compliance measures, but since this government took over in 2015, under the strong leadership of the Honourable Prime Minister himself, the creation of a Financial Crimes Commission was actually included in the government program itself. And this government has been working assiduously to be able to bring about bold reforms. And Mr. Speaker, sir, since the publication of the 2018 report of the FATF listing Mauritius in its grey list, this government, especially, I would say, I would like here to commend my colleague and colistier, Honourable Sihatan, the Minister of Financial Services and Good Governance, has left no stone unturned in turning things around. Through the relentless efforts of this government, spearheaded by the Honourable Prime Minister himself, Mauritius has been able to exit the grey list within 18 months, which is a record in terms of duration. And today, being compliant with 35 out of the 40 recommendations, Mauritius has actually become a partner in helping the FATF achieve its objectives, and our professionals are today actively engaged as ESAMLAG reviewers across Africa. The Honourable Prime Minister and Honourable Sihatan mentioned details about it early in the House. But, Mr. Speaker, sir, let me remind the House and our people that our nation's rise as an international financial centre of good repute is not merely a stroke of luck. It is the fruit of assiduous labour, strategic vision, and an unwavering commitment to combating financial crimes in all its forms. And Mr. Speaker, sir, it is precisely at this conjuncture to be able to sustain our commitment and to keep the religious fight against financial crimes on. But today, this bill has been tabled by the Honourable Prime Minister. The FCC will be the apex body to detect, investigate, and prosecute financial crimes. It will henceforth be the new legal framework replacing the Prevention of Corruption Act, the Asset Recovery Act, the Good Governance and Integrity Reporting Act, and Part 2 of the Financial Intelligence and Anti-Money Laundering Act, which will be repealed. And all this, Mr. Speaker, sir, is not comme par hasard. As I mentioned earlier, it was in the vision of the Prime Minister to fortify the country's position as a trusted and reputable financial jurisdiction on the global map. Mr. Speaker, sir, rigor, discipline, collaboration, diligence, all this has been exerted for the setting up of the FCC to stand as and make our nation more resilient. As mentioned by the Prime Minister earlier, a national committee was set up under the chair of the Financial Secretary, and extensive consultations were carried out by this national committee. Honorable Boulel earlier said that the Honorable Prime Minister did not mention with whom consultations were held. Maybe he was not listening. But let me remind him what the Prime Minister had stated, that when the first draft was ready, it was circulated, and a second set of wide consultations were carried out. But it's good to note that the Ministry of Finance and Economic Development, the Ministry of Financial Services and Good Governance, the Office of the DPP, the Police Department, the ICAC, the FIU, the IRSA were all involved. And as he mentioned, all submissions have been carefully analyzed. Monsieur le Président, depuis la semaine dernière, quand ce projet de loi fut rapporté en première lecture dans cette Chambre, les critiques n'ont cessé de pleuvoir. Alors que certains qualifient la FCC comme très dangereuse, d'autres osent parler de philosophie dictatoriale. Et leur campagne d'instiller la peur dans la tête de la population n'arrête pas. Et l'honorable Boulel parlait justement de déjà-vu. Ben oui, c'est du déjà-vu. Parce qu'à chaque fois que ce gouvernement vient à l'avant avec un projet de loi, des insignations telles quelles ne manquent pas. Que c'était pendant le Covid Bill qu'on avait apporté ce projet de loi pour pouvoir protéger la population à la Chambre, que ce soit le Cybercrime Bill, que ce soit le IBA Act, les membres de l'autre côté de la Chambre n'ont cessé de semer la psychose dans l'esprit de la population. Mr. Speaker, sir, with the unprecedented, or if I dare say, the appalling speed with which financial crimes are being devised and destroying lives, I am shocked how some honourable members on the other side of the House dare to say that this bill should be thrown to the dustbin. But here, Mr. Speaker, sir, on this side of the House, we have taken the oath to combat financial crimes. And the Honourable Prime Minister has been very bold in his statements earlier in this House. So, if we all know what can be the effects of financial crimes, I don't know if honourable members on the other side of the House understand or realize the disastrous effects of financial crimes or the money from illicit proceeds, and how these can touch the lives of our children in this country. Or they are not, I don't know if they realize or they accept it or they are tolerant of it, but I believe that it's our duty to all come together to stop this mafia. Then why this fear? What are you afraid of? Des billets neufs dans les coffres-forts? Or I should say that it takes courage to bring reforms, and being bold is not everyone's cups of tea. Mr. Speaker, sir, I will not take long on the different sections of the bill because of a time constraint, but I just wish to say that as per Section 6 of this bill, which enlists the functions and powers of the Commission, the list is very comprehensive, detailing the responsibility and the various units being set, from the financing of drug dealing investigation unit, the declaration of assets unit, the unexplained wealth unit, amongst others, and the Education and Prevention Division, as well as the Legal Division. And all these, I believe, are part of the holistic approach which has actually been recommended by the SMLAG 2018 evaluation report on Mauritius. This is also in line with recommendations of a Commission of Inquiry on Drug Trafficking, which recommended more coordinated means and encourages more collaboration. Mr. Speaker, sir, the FCC will now be empowered with the necessary tools, bodies, resources to be able to do this coordination and collaboration, and as an umbrella body will be equipped with a new, robust and harmonized structure which will serve to enhance the effectiveness of a system. The United Nations Recommendation on Drugs and Crimes had also put forward proposals for the setting up of a centrally managed entity. Hence, the FCC is a testament to our government's determination to stamp out corruption and financial crimes from every corner of this country. Mr. Speaker, sir, what I like about the Education and Prevention Division in this bill is actually this part, the preventive research part, that is research undertaken to assess the causes which can give rise to financial crimes and the underlying consequences on, for instance, the social and economic structure of a country. Much efforts are also being deployed in the early detection of financial crimes and analyze the best ways to be able to eradicate them and review existing practices and procedures. Just like Honorable Joel mentioned earlier in the House, there will also be wide sensitization campaigns which will be carried out both with the public and the private sector. And it is a fact that many people are not informed about what verily constitutes financial crimes. Hence, this bill will serve to reinforce public campaigns alerting the public on dangers of financial crimes and also help them to understand the complaint reporting mechanism for same. It is also a fact, Mr. Speaker, sir, that today most of our kids, our teenagers, our youths spend so much time on their phones, internet and social media, and the risk of financial crimes are very inherent therein. As mentioned by the Honourable Prime Minister earlier, we are now faced with new breeds of criminals and new forms of electronic frauds, and new types of financial crime scam. Our kids may not even be aware of the dangers lurking ahead. This bill is innovative in as it goes as far as reaching the school curriculum so as to educate our children on the dangers of financial crimes. Hence, the FCC aims at creating a culture of compliance and capacity building. It will provide training programs, workshops, and guidance on with knowledge and also on tools which can be necessary to detect, prevent, and report suspicious activities effectively. This bill also highlights the coordination and collaboration with law enforcement agencies and aims at facilitating prompt exchange of intelligence, scientific and technical information, and the conduct of joint operations which are geared towards the eradication of financial crimes. And it demonstrates that the FCC's work will not be confined only within Mauritius' borders. Through bilateral and multilateral engagements, international cooperation will be fostered, and exchanging information and expertise with global counterparts will be key. This collaborative approach will strengthen our ability to combat transnational financial crimes, and hence emphasizing our commitment to global financial stability. Mr. Speaker, sir, the nomination of a Director General of the FCC has been the center of various debates, and the main criticism till now has been that the latter will be chosen by the Prime Minister. But the bill lays it clearly that he will be nominated by, the Director General will be nominated by the President of the Republic as advised by the PM in consultation with the Leader of the Opposition. And earlier, the Prime Minister reminded the House that this has been the standard procedure since 2006, since the abolition of our Operations Committee. Monsieur le Président, j'ai entendu les louanges par l'honorable Béranger un peu plus tôt sur les compétences, l'expérience, la capacité du DPP. Mais j'ai aussi une question. Avant même que le directeur de la FCC soit nommé, on juge déjà ses compétences et on compare ses compétences à ceux du DPP. Je ne doute pas des compétences du DPP, mais juger sans même savoir qui va être le directeur et quelles compétences il va avoir, la question se pose. J'ai aussi entendu les membres de l'autre côté de la Chambre marteler que ce projet de loi évoque des possibles défis constitutionnels. Bien sûr, en parlant de l'article 72 de la Constitution un peu plus tôt, que ce soit l'honorable Mohamed, l'honorable Béranger et d'autres membres de l'autre côté de la Chambre, ils ont évoqué cette possibilité. Mais comme l'a justement expliqué l'honorable Premier ministre, il a réitéré à la Chambre que les pouvoirs constitutionnels du DPP, comme conférés par l'article 72 de la Constitution, ne seront guère affectés. D'ailleurs, en cas de poursuite, le DPP pourra à n'importe quel moment intervenir. D'ailleurs, comme l'a si bien expliqué l'honorable Colin Davelliou un peu plus tôt, sous forme d'anecdotes et d'exemples, en cas de décision de poursuite, ou même d'abandon de poursuite, quand la concentration de pouvoir et de décider est dans la main du DPP, tout bon même, mais comme l'a dit l'honorable Colin Davelliou, personne n'est au-delà de la loi, même pas le DPP. So, Mr. Speaker, sir, I will just quickly conclude. To conclude, Mr. Speaker, sir, the FCC will be what I believe the bulwark against the pernicious threats of financial crimes, thereby spearheading the preservation of our financial system's integrity and fostering an environment conducive to sustainable economic development. Through its multi-pronged approach englobing early detection, regulation, prevention, and public-private collaboration, the FCC will be instrumental in taking Mauritius to new heights as a jurisdiction of choice for global investors and businesses. And I truly believe that the FCC will stand as a beacon of integrity and resilience, allowing our country to continue to shine as a paragon of financial integrity and good governance. And therefore, I fully support this bill. Thank you.
Thank you, Mr. Speaker, sir. After having heard some members on the other side of the House, and at the end of the day, they will try it to prove that on the other side of the House, we have those who want to fight financial crimes. They are those with clean hands. They are those who will make sure they uproot financial crimes from the society. And on this side of the House, they will try to show, through their speeches, intervention, that we are against the uprooting, the combat against financial crimes. This is not so. I heard a seasoned politician, Honorable Siwatan, earlier, and recently the speaker who spoke before me, Honorable Jutan. Basically what they are saying, what is their discourse? That this opposition, we who are intervening, we are instilling fear in the public. Honorable Jutan went on further by saying, on est en train de semer la psychose. On est en train de semer la psychose. Si psychose il y a, c'est un produit de la cuisine MSM, qui est fort de produire des recettes pareilles, qui traumatise la population de temps à autre avec ses lois rétrogrades, antidémocratiques, anticonstitutionnelles. Et on a vu dans le cas de Sigom comment cette loi était anticonstitutionnelle. Les membres de la profession légale, les représentants de la société civile, et bien que l'opposition parlementaire et extra-parlementaire se mobilisent et parlent d'une seule voix. Merci, la cuisine MSM. Vous avez eu ce courage de nous réunir et vous parlez de division. Merci. Cette loi a interpellé des intellectuels, des juristes, des membres de la société civile. Ce n'est pas nous qui ont créé la psychose, instilling fear, comme disent certains de l'autre côté de la Chambre. Commençons par un éclairage qu'un sociologue citoyen, Malenoudia, a écrit sur ce projet de loi. L'heure est à mise en place et la mise en œuvre rapide, avec tous les moyens nécessaires d'une stratégie ayant pour objectif d'unir toutes les forces attachées aux valeurs et principes fondamentaux de la démocratie pour bloquer la concrétisation de ce projet de loi si dangereux pour la séparation de pouvoir et la garantie des droits citoyens, fondement de la République mauricienne. Nous, c'est bien de se moquer de l'opinion des gens. Ils sont très forts là-dessus, parce que seulement eux, ils ont raison. They live in the devil's paradise, let them live. Nous, je continue ce que Malin nous dit. Nous ne nous trompons pas. Nous sommes en guerre contre les fossoyeurs de la République mauricienne démocratique. PKJ n'a pas été mandaté lors des dernières élections de 2019 de porter ce projet de loi. Il va plus loin. Il va plus loin. Il va plus loin. Il dit avec le Financial Crime Commission, PKJ veut se doter d'une puissante tronçonneuse pour tenter d'en finir avec les oppositions et d'installer une autocratie et régner en autocrate absolu. Pas seulement lui, il va dire ça. Tout à l'heure, je vais faire référence à Videm. Il faut écouter ce que les gens disent, ici ou ailleurs. Et ça, ils n'aiment pas. Pourquoi? Parce que ICAC disait quoi? Nous pas guette figure. Mais qu'est-ce que le Premier ministre est en train de dire lorsqu'on est en train de montrer des vérités qui font mal? Il dit à l'honorable Echanjuman, al ghetto figure. Et cette loi-là va plus loin. Cette loi-là va... Chez vous aussi, il y a des condamnés, monsieur le Premier ministre. Allez veiller. Chez vous aussi, il y a des condamnés qui sont assis parmi vous. Parmi vous.
Order.
Mais ça, c'est pas le débat. Je continue.
Order, both sides of the House. Order. Concentrate on the bill.
Plus loin. C'est pas seulement get figure, pour get laptop, pour get qui peut arriver dans la case, pour get qui peut arriver dans la toilette, pour get qui peut arriver partout. By looker. Radar. C'est ça, ils aiment radar. Ils placent des radars dans des places stratégiques. C'est ça, leurs apanages.
Mr. Speaker,
c'est ça qu'ils aiment.
Mr. Speaker, sir, I have a point of order.
Who has a point of order?
I do. I just heard Honorable Echanjuman say to the Prime Minister, Tuntui Jimun.
So you have to apologize.
It's true.
You have to apologize. No discussion.
It's true, Mr. Speaker.
It's true?
Yes.
I am naming you for that. If you say it's true, I am naming you for that.
But it's public domain.
So, your name, withdraw from the chamber. Withdraw. No discussion. Withdraw. Your name. Get out from here, I say. Sergeant at arms. Sergeant at arms, take care of the gentleman. No further discussion. Move out from here. Don't discuss anymore. You have been named. You have been named. Get out from here. Get out from here.
Je continue, Monsieur le Président, et je vais citer une autre personne, cette fois-ci un juriste, Richard Roux. La future Finance Crime Commission est dans la droite ligne de l'agenda du MSM, la mainmise sur les institutions. Si le regroupement sous un seul toit des compétences de l'ICAC, de l'IASA et de la RID est souhaitable au plan financier et administratif, en revanche, l'indépendance du futur FCC est totalement sous cloche. Mr. Speaker, sir, we are trying to show that this bill has certain parts, certain sections, which go counter to what is being professed in this House. And Richard Roux tries to explain it. Comprenez qu'actuellement, il n'y a obligation pour l'ICAC de communiquer le dossier qu'en fin d'investigation. Le DPP ne peut demander, contrairement à ce qui se pratique pour les dossiers qui sont entre les mains de la police, le dossier est ainsi réclamé des compléments d'enquête, c'est cette disposition qui aura permis à Bikari de dormir sur des dossiers défavorables au gouvernement.
No, I stop you. I reserve the right to stop you and not preventing you from continuing your speech if you continue along that line.
Which line, sir?
Be careful of what you say in this House.
Which line, sir? Which line?
I have nothing to prove to you. You correct your speech and you continue.
I am talking on the bill. It's freedom of speech.
There is freedom of speech. There is limit for freedom of speech. You cannot insinuate things which are not accurate.
I am going to validate it. I am going to validate it. And if it is not validated, you expel me. I challenge you now.
What are you saying?
I am going to validate it.
I suspend your speech. I move to the next orator. The next orator would be...
Thank you.
The next orator would be Honorable Ramcharan. You get out. You get out from here. You get... I am naming you. I am naming you. Okay. I am naming you. Sergeant at arms, take this man out. Sergeant at arms, you have police duties. You have police duties, police powers. Don't assault the policeman. Don't assault any policeman here. No member has a right to assault any policeman. Carry him away. Carry him away. Carry him away. Get up. Honorable Ramcharan.
Thank you, Mr. Speaker, sir. Mr. Speaker, sir, tonight the echo of the opposition sounds strangely familiar. Their speeches recall a time gone by during debates over changing the independent Broadcasting Authority Act. Their objective then, as today, was to sow fear, revolt, and psychosis among the population. However, since this bill passed in 2021, let's take a look at the reality of the predictions they made. How many of these prophecies have come true? How many arrests and closures of private radio? People should recall. How many closures of private radio stations have actually taken place? Facts often speak louder than words, Mr. Speaker, sir. And it is crucial to evaluate the relevance of their predictions in light of the reality we live in today. And we have just seen the drama going on the other side. And this has been throughout the 4 years I've been sitting in this august assembly. Mr. Speaker, sir, it is with immense pleasure and humility, even at this time of the hour, that I'm addressing this august assembly on the Financial Crimes Commission Bill. Indeed, Mr. Speaker, sir, the Honourable Prime Minister should be heartily congratulated for presenting a long-awaited bill, maybe not for the opposition, but for the whole population and for the sake of this country, for this government, which aims at transforming the prevention, combating, and investigations of financial crimes in Mauritius. Undoubtedly, undeniably, through this bill, we are equipping our country with one of the most advanced financial crime legislative and operational frameworks in Africa. Our country has already achieved tangible results through the groundbreaking setup of the Financial Crime Division of the Supreme Court in 2020, which has considerably impacted the successful prosecution of a number of cases. In fact, the streamlining of financial crimes at the Supreme Court allows specialized hearings of corruption and money laundering cases by erasing the backlog of cases at the Supreme Court. However, Mr. Speaker, sir, the Financial Crimes Division was only one piece of the puzzle, and the most important piece is the investigation and prosecution, which has unfortunately not been properly aligned over the last few years. During the debates today, Mr. Speaker, sir, we have been hearing, we will hear, and we just heard at length from the Nonye Pabon opposition, who I am sure will come up with all angles, some have already proved it, of statistics, all angles of statistics to demonstrate that the ICAC and other financial crimes combating institutions have not performed. In fact, as a member of the Parliamentary Committee of ICAC, in fact, as a member of the Parliamentary Committee on ICAC, I have seen the amount of work which has been delivered by the hard-working staff of the ICAC. And I do thank those officers for their service and loyalty to the country and their dedication to their profession in spite of the difficult conditions. It would be extremely unfair and biased to argue that the ICAC has not been performing, as the evidence suggests the contrary. This is unfortunately very much a narrative we have to expect from the opposition members. However, Mr. Speaker, sir, the real question should be whether the ICAC is being allowed to be effective as possible through its operations. The answer is unfortunately no. Opposition members who were once part of the ICAC Parliamentary Committee knew perfectly of the impediments being faced by the ICAC investigators and prosecutors. But unfortunately, their political narrative of portraying the ICAC as a non-performing organization was stronger for them. Unfortunately, Mr. Speaker, sir. It is thus important to disclose the challenges being faced by the ICAC. I have also taken care to listen to the media intervention of certain opposition members on the same topic. And for once, we can agree. In fact, apart from the Asset Recovery Investigation Division, from the Financial Intelligence Unit, and the Integrity Reporting Services Agency, the ICAC also operates within a complex web of institutions which also include the Mauritius Revenue Authority, the Financial Services Commission, the Gambling Regulatory Authority, and as well as the police, where all institutions are individually combating financial crimes. Inevitably, the ICAC and other institutions have to operate under non-aligned legal frameworks, and all ministries, which led to challenges in the sharing of information, alignment on legal positions, and risk of non-cooperation, which has been blatantly visible on many occasions in court cases. Unfortunately, who benefits in such cases? It is the gros poissons, as we say, who wait and watch different law enforcement authorities tear each other apart while their cases are being left for years in our courts. Ultimately, it is at the detriment of the taxpayers who have to fund long cases without any results, but who are also victims of day-night robberies from financial criminals. Mr. Speaker, sir, this can no longer continue, and only a unified, focused, and aligned organization can unblock the situation. However, after hearing the opposition, they are insistent that the only solution is the setting up of a UK-style serious fraud office, which they argue will solve all the issues being faced by the ICAC, including those of competing agendas in aligned and unaligned legal frameworks. Unfortunately, this is a typical position of the opposition, which shows their purely political and unthought narrative. Let us look in more details at how the Serious Fraud Office, whose setup was legislated in 1987. The very purpose of the Serious Fraud Office was prescribed by the Lord Roskill report in 1986, and that was to ensure that a single authority conducts both the investigation and prosecution of the fraud cases, which is also the case for the Financial Crime Commission. Moreover, at the Bond Network, the umbrella organization representing 370 international development organizations, which confirmed that the Serious Fraud Office met 3 of the basic tenets of anti-fraud and corruption. Namely, the first one, with investigation and prosecution teams should be combined in the same agency. Secondly, the corruption must be a top priority for that agency and not simply one amongst many. And lastly, that there must be a specialist corruption teams. Interestingly, the Financial Crimes Commission also meets all these 3 preconditions, are in fact very similar in purpose and in action. Thus, Mr. Speaker, sir, given that the SFO and the FCC, the Financial Crimes Commission, operate in the similar fashion in the opposition's issues with the Financial Crime Commission truly relevant and warranted? The simple answer is no, obviously. Their obsession with the serious fraud office is a mere illusion, with the dream of but cannot be achieved. Mr. Speaker, sir, so what is the real problem of the opposition members with the Financial Crime Commission? La main propre, la tête haute. Their main issue, I guess, is the timing. Mr. Speaker, sir, they have been talking the talk for more than 20 years now. An illusion they take from their shelves prior to each election and which they forget even when in power. Contrary to our government, to this government, our Prime Minister, Honorable Pawan Kumar Jagannath, has walked the talk and is delivering on his engagements to the population. Moreover, Mr. Speaker, sir, the opposition members are seriously scaring the population. They're instilling fear. Well said by Honorable Ganga Prasad. They are really instilling fear, scaring the population from mere citizens to individual and small businesses, Mr. Speaker, sir. If someone has to be scared of, it is not the population, as the Financial Crimes Commission is a steamroller, Mr. Speaker, sir, with a powerful engine which will leave no stones unturned to casse les reins. To casse les reins, we say, of the criminals. Those who has to be scared are those who cannot explain their amassed wealth in their coffers, dans les coffres. Those who in soutien et finance drug traffickers for years while they were in power. Drug trafficking is a huge business for some, and though the Finance and Drug Dealing Investigation Unit, a unique and dedicated team, the Financial Crimes Commission will strike these drug investors at the very core. Perhaps that's what scares them, Mr. Speaker, sir. And really, they should be scared. When you hear all these cases on the opposition side, drug trafficking, drug traffickers, money in coffers, unexplained wealth, this is why they are feared of, Mr. Speaker, sir. The other problem, Mr. Speaker, sir, is the nomination of the Director General of the Financial Crimes Commission. If one compares the Director General of the tax requirements compared to that of the FCC's Director General requirement, it is clear that the FCC has more stringent requirements. Why so? Only because we need the best qualified person for this position. As well, the opposition talk about bringing only a foreigner to their dream serious fraud office, which they think will solve all the problems instantly. The Honorable Prime Minister is, through the FCC, focusing on the results for the population and the country, rather than the opposition, who are already offering the job to foreigners. They have also followed a basic principle of dissociating the office and the person. The FCC will combine the best independent talents of the country, who will diligently conduct their investigations and prosecutions as it is grossly unfair, but also, unfortunately, typical of the opposition to prejudge before they even start their jobs. Mr. Speaker, sir, this bill has proven how the opposition is in a state of disarray, and they are desperately looking for imaginary arguments to try and pin down the Financial Crimes Commission. May the rest show that their attempts are futile. Mr. Speaker, sir, as the opposition is running out of things to throw at us, let it be clear that the Honorable Pravin Kumar Jagannath single-handedly silenced the critics on the other side of the House today. Mr. Speaker, sir, Honorable Pravin Kumar Jagannath is committed to break the coffers and the pockets, les poches of financial criminals. And the Financial Crimes Commission will ensure that the country is fully equipped to protect the interests of the country and the entire population. Mr. Speaker, sir, I'm done. Thank you.
Members, I'll suspend the sitting for some minutes.
Please be seated. Honourable members, I named Honourable Juman earlier for his grossly disorderly conduct and for disregarding the authority of the chair.
Mr. Speaker, sir, in view of your decision to name the Honourable Juman, I beg under Standing Order 17.3 to take the time of the House for urgent business.
Seconded. The question is that the Honourable Prime Minister be allowed under Standing Order 17.3 to take the time of the House for urgent business. Those in favour say aye, those against say no.
Aye.
Ayes have it.
Mr. Speaker, sir, having obtained your permission, I beg to move under Standing Order 29.1 to present a motion without notice.
Seconded. The question is that the Honourable Prime Minister be allowed under Standing Order 29.1 to move a motion without notice. Those in favour say aye, those against say no.
Aye.
Ayes have it.
Mr. Speaker, sir, in view of your decision to name the Honourable Juman, I beg to move that the Honourable Juman be suspended from the service of the Assembly for today's sitting and the next two sittings unless unreserved apologies are tendered to the House.
Seconded. The question is that the Honourable Juman be suspended from the service of the Assembly for today's sitting and the next two sittings unless unreserved apologies are tendered to the House. Those in favour say aye, those against say no.
Aye.
Ayes have it. Honourable members, I named the Honourable Gangappa Assad earlier for his grossly disorderly behaviour, for challenging the authority of the chair and for using abusive words towards the chair.
Mr. Speaker, sir, in view of your decision to name the Honourable Gangappa Assad, I beg under Standing Order 17.3 to take the time of the House for urgent business.
Seconded. The question is that the Honourable Prime Minister be allowed under Standing Order 17.3 to take the time of the House for urgent business. Those in favour say aye, those against
aye.
Ayes have it.
Mr. Speaker, sir, having obtained your permission, I beg to move under Standing Order 29.1 to present a motion without notice.
Seconded.
Seconded.
The question is that the Honourable Prime Minister be allowed under Standing Order 29.1 to move a motion without notice. Those in favour say aye, those against say no.
Aye. Mr. Speaker, sir, in view of your decision to name Dr. the Honourable Gangappa Assad, I beg to move that Dr. the Honourable Gangappa Assad be suspended from the service of the Assembly for today's sitting and the next four sittings unless unreserved apologies are tendered to the House.
The question is that Dr. the Honourable Gangappa Assad be suspended from the service of the Assembly for today's sitting and the next four sittings unless unreserved apologies are tendered to the House. Those in favour say aye, those against say no. The ayes have it. The next orator, MP Wuchit.
Yeah. Thank you, Mr. Speaker, sir. I feel it is my utmost duty and responsibility to offer my address on this bill to this august Assembly and to the public at large. The explanatory memorandum of this bill speaks of lofty ideals motivating the current government and the aims intended to be achieved by introducing this bill. However, there are hidden agendas and sinister motives behind this piece of legislation. Several provisions contained therein are highly questionable as they constitute frontal attacks on the powers of the Director of Public Prosecutions, and they intend to strengthen political intrusion and interference in the enforcement of the laws of the Republic of Mauritius. Mr. Speaker, sir, I first proposed to address the House on Section 10, subsection 2, paragraph E of the bill, which reads as follows, quote, "The Director General shall be a person who has served in an anti-corruption body at a senior level for a period of at least 5 years and has wide knowledge and experience at national and international level in the field of financial crimes, unquote. Mr. Speaker, sir, I should confess, I was very blissful when I perused Section 10, subsection 2, paragraph A, B, and C of this bill, which opened the gate to the appointment of a person who has served as a judge of the Supreme Court to the post of a Director General. I think all my countrymen who adore democracy, impartiality, independence, integrity would be happy and elated to see a retired judge as the head of an institution whose aim is to combat financial crimes. This would bring a ray of hope in the otherwise current bleak and gloomy environment. It would be almost impossible for the Prince du Jour to pressurize a retired judge to take decisions just to please them. But my bliss, Mr. Speaker, sir, was short-lived when I came across Section 10, subsection 2, paragraph E of this bill, which I quote above. It is crystal clear that this paragraph has been introduced in this bill to pave the way for the current Director General of the Independent Commission Against Corruption to be appointed as Director General of the Financial Crimes Commission. Mr. Speaker, sir, Section 10, subsection 2, paragraph E of this bill is tailor-made for Mr. NB. There is no doubt about it. Who does not know the closeness of Mr. NB with the current government? There are so many files against the poche de pouvoir which are accumulating dust in mobile drawers at Les Réduits Triangle. Is the Mauritian population prepared and ready to live the same experience with Mr. NB as the head of the Financial Crimes Commission? This is a question, Mr. Speaker, sir. I am hereby making an earnest appeal to the Honourable Prime Minister to kindly and seriously consider the removal of Section 10, subparagraph 2, subsection 2, paragraph E from this bill, if he does not want the contemplated Financial Crimes Commission to become an abject political tool to pester political opponents. I am sure and certain that there must be other persons as capable, if not more capable, than the said Mr. NB on Mauritian soil. Mr. Speaker, sir, I will now turn to the mode of appointment of the Director General of the contemplated Financial Crimes Commission. According to Section 10, subsection 1 of this bill, it is the Prime Minister who decides all. The President of the Republic will appoint, but upon the advice of the Prime Minister after consultation with the Leader of the Opposition. The Prime Minister is, above all, a politician, an homme de parti. He will no doubt choose a person who will toe his line as the head of the contemplated Financial Crimes Commission, save and except if a retired judge of the Supreme Court is ultimately chosen. This bill militates in favor of an over-concentration of powers in the hands of one man, that is the Director General. The appointment of the Director General of the contemplated Financial Crimes Commission cannot be left in the hands of a politician. This will not be in line with the sacrosanct principles of a vibrant and respected democracy, Mr. Speaker, sir. I am making an earnest appeal to the Honourable Prime Minister to review Section 10, subsection 1 of this bill and kindly consider the possibility of entrusting the appointment of the Director General in the hands of an independent and impartial body. If this is not done, we will run the risk of being called une république bananière. Mr. Speaker, sir, I am taking strong exception to the provisions of Section 10, subsection 3, paragraph A of this bill. Once again, it is a Prime Minister who is called upon to fix the term and conditions of appointment of the Director General of the contemplated Financial Crimes Commission. Section 10, subsection 3, paragraph B stipulates that the Director General is eligible for reappointment. And what about the appointment of the 4 commissioners who will sit on the commissions, Mr. Speaker, sir? According to Section 7, subsection 3, paragraph A of this bill, it is the Prime Minister who decides whom he will appoint and on what terms and conditions. The same rule will apply for their reappointment as per Section 7, subsection 3, part B. It goes without saying that it is a Prime Minister who will decide both about appointment and reappointment. The President of the Republic can, but will not oppose. Consultation with the Leader of the Opposition is a mere clause de style. Monsieur le Président, as the Prime Minister will decide everything about who will rule the Commission, what impartiality and independence of action can we expect from the contemplated Financial Crimes Commission? In these circumstances, what is the importance of Section 4, subsection 3 of this bill, which reads as follows, quote, the Commission shall, in the discharge of its functions and exercise of its powers, not be under the direction or control of any body or authority, unquote. Mr. Speaker, sir, I am mandated to say that the application of sections 10, subsection 1 and 3, paragraph A and B, and section 7, subsection 3, paragraph A and B of this bill will turn section 4, subsection 3 of this bill into ridicule and will dilute its effect. I am humbly inviting the Honorable Prime Minister to review all the provisions related to the appointment and reappointment of the Director General and the Commissioners. Mr. Speaker, sir, I would now like to make some observations on the provisions of Section 5, subsection 1, paragraph E of this bill, which stipulates that, I quote, there shall be within the Commission such other division as the Commission may, with the approval of the Minister, set up, and such division shall have such functions and powers as the Commission may determine, unquote. Mr. Speaker, sir, Parliament will pass the Financial Crimes Commission's bill bestowing upon the Financial Crimes Commission specific powers to investigate into designated offences and to institute criminal proceedings against qui les droits. Section 5, subsection 1, paragraph A of this bill shall create an investigation division which shall discharge such functions and powers conferred upon it by Section 6, subsection 1, paragraph C and D. And Section 5, subsection 1, paragraph B of this bill shall create an asset recovery division which shall discharge such functions and powers conferred upon it by Section 6, subsection 1, paragraph E, F, and G. And Section 5, subsection 1, paragraph C of this bill shall create an education and preventive division which shall discharge such functions and powers conferred upon it by Section 6, subsection 1, paragraph H. And last, the Section 5, subsection 1, paragraph E empowers the Commission to create other divisions with the approval of the Honorable Prime Minister. So far, so good, Mr. Speaker, sir, but it will be appropriate in a democracy to leave it to the 5 appointees to determine the functions and the powers of all the new divisions. Is it correct, Mr. Speaker, sir? No. This bill is silent on the functions and powers of new divisions created subsequently. Parliament confers powers, but here 5 appointees will decide about the powers of new divisions. No delimitation have been provided in this bill. What will happen in case of abuse of power, Mr. Speaker, sir. This sends chill down the spine. It is germane and pertinent to review Section 5, subsection 1, paragraph E of this bill, and a mechanism must be earmarked to oversee and limit the functions and especially the powers of new divisions created by the Financial Crimes Commission. Mr. Speaker, sir, my last subject to address would be the provisions of Section 6, subparagraph 1, subsection 1, paragraph I of this bill, that is a power conferred on the Financial Crimes Commission to, I quote, prosecute financial crimes and any other offense under this Act and the Declarations of Assets Act, unquote. Criminal proceedings will be instituted straight away by the Financial Crimes Commission without passing through the Office of the Director of Public Prosecutions. Mr. Speaker, sir, the Office of the Director of Public Prosecutions is a constitutional body, and its independence, impartiality, and integrity cannot be impeached. The Office of the Director of Public Prosecutions represents the pride of the Mauritian nation. Now, will it be criminal proceeding decided by 5 appointees of the Honorable Prime Minister? I do not hesitate to say that this is a veiled attempt to dilute the constitutional powers of the Director of Public Prosecutions. This is a frontal attack on the constitutional right of Mauritians to have an independent and impartial body which decides on criminal prosecutions. Section 6, subsection 1, paragraph I of this bill is unconstitutional and should be removed forthwith, Mr. Speaker, sir. Before I end, Mr. Speaker, sir, though not all the provisions of this bill are objectionable, yet it is my considered view that the sections of this bill on which I have adumbrated required urgent attention as they violate the principles of democracy, fairness, impartiality, and independence. I am not against innovation, Mr. Speaker, sir, but I am opposed to laws which offend the Constitution and which are designed to be used as a political tool to harass and cause prejudice to citizens who do not toe the line of the government of the day. Thank you, Mr. Speaker, sir.
Honorable Ramdani.
Mr. Speaker, sir, I move for the adjournment of the debates.
Seconded. The question is that the debate be now adjourned. Those in favor say aye, those against say no. Ayes have it.
Mr. Speaker, sir, I move for adjournment of the House to Friday, the 15th of December at 1500 hours.
Seconded. The question is that the House be adjourned to Friday, 15th of December 2023 at 3 p.m. Those in favor say aye, those against say no. The ayes have it. The House stands adjourned. Adjournment matter? None.